Alex here with a legal nuts and bolts video on stays. What I mean by stay is a temporary, let's say suspension or setting aside of a judge's order that you're challenging on appeal or by writ petition. There may be other ways to get stays. I'm not thinking of that off the top of my head right now. So if anyone here has ever gotten a stay on an order using some other mechanism, feel free to let us know in the comments below. I'm specifically talking about appeals because a lot of people ask about appeals on this channel because I've won 4 appeals and I have some success stories there. So they ask about stays because they basically are worried about the current order being binding and enforceable. Typically, it's child custody questions because that tends to be the most popular subject on my channel. So people are worried about being held in contempt of court while their appeal is pending or while their writ petition is pending. If you don't know what a writ petition is, I'll put a card up at this point in the video so you can click on it and take a look at what those are. Some people are confused by that, but it's another type of appeal. Anyway, except in the rarest of circumstances from what I've seen, stays don't automatically trigger when you challenge a judge's order. I can think of 2 examples off the top of my head, and one of them isn't even challenging a judge's order. One of them is a bankruptcy stay. It's automatic stay. A bankruptcy automatic stay triggers at a certain point in the process, and it basically stops all the creditors from annoying you and harassing you with the debt collection efforts because you're in bankruptcy. So the other time I've seen it is in Nevada Justice Court summary eviction proceedings. Apparently, according to the court rules, or it might even be in a statute, I can't remember now, if you file an appeal from a justice of the peace's summary eviction order, you get an automatic stay until the district court resolves that appeal. In all other situations, I haven't seen any such automatic stay. You have to ask for the stay. Now, in Nevada, according to the rules of appellate procedure that I've looked at, remember they might change. If this video is up 3 or 4 or 5 years later, who knows what's changed. But anyway, according to the Nevada rules of appellate procedure, you first have to ask the district court for a stay before you can go and ask the Supreme Court for a stay. So if you file your motion for stay in the district court, you're basically asking the district court to please stay its order until the Supreme Court of Nevada or Court of Appeals resolves the matter. If the district court grants it, you're pretty much done, and you don't have to worry about that order basically coming back to bite you while you're waiting for that appeal or writ petition to resolve. It's suspended, it's temporarily ineffective. Once the appeal is resolved or the writ petition is resolved, the order takes effect again. And they usually will tell you, they'll usually lift the stay. Either the district court will, or it'll automatically trigger, or in the event that the district court denied your stay and then you went to the Supreme Court and filed your motion for stay there, consistent with the Nevada rules of appellate procedure. Remember you got to check your own states because other states might be very different. With respect to something like this could be completely different in all 50 states. Anyway, if the Supreme Court grants your stay, then typically I'll see something like them lift the stay when they dispose of the appeal or the writ petition. So with that being said, as I mentioned in the beginning of the video, if you get a stay, you're lucky. You don't have to worry about that court order being used against you. You don't have to worry about contempt of court. You don't have to worry, if it's a judgment for money, you don't have to worry about them trying to execute on the judgment and take your assets and garnish your wages. You can just pretty much have some peace of mind that as long as that appeal is pending and that stay is effective, you don't have to worry about that order that you're challenging. If the stay is denied, both in the district court and the Supreme Court, or you don't even ask for it, that order is enforceable while you're on appeal. So if it's a judgment, they can start taking your money. If it's some kind of a child custody issue, which is a popular topic on my channel, you could be held in contempt of court while that appeal is pending. Some people ask what happens if you don't get a stay and then you're held in contempt or the money's taken from you if it's a money judgment and then you win your appeal. This does happen sometimes and it sucks because you got to get your money back. And that's a whole nother thorny issue and topic. If you've been held in contempt, you'll probably get your money back if you were fined. I'm not even sure though if you will. And if you've been put in jail, you can't get your jail time back. That's just gone. So that being said, you should really seriously think about getting a stay if you're filing an appeal, because otherwise, I mean, a lot of times the object of the appeal is frustrated by you having to abide by that order for who knows how many months or years that appeal is pending. So, in fact, there are a few different criteria that at least in Nevada, that the Nevada courts and the Supreme Court considers when you request a stay. Off the top of my head, I can think of 3 or 4. One of them is if the object of the appeal or writ petition will be frustrated by you having to comply with that order. The other one is whether or not your opponent will suffer. I think they call it undue harm or something, or prejudice. I don't know, something like that. Whether they're going to suffer by the order being stayed. And then the third one is whether you're going to suffer by the order not being stayed. And then the fourth one, whether or not, how likely you are to win. So that's a pretty big analysis that they go over. If they don't think you're likely to win, you probably won't get to stay. But as I mentioned, some quirky situations, I've seen it before where stay is denied, a person does end up winning, and then they have to figure out how to get their money back. It's kind of annoying when that happens, I imagine. It hasn't happened to me before. In fact, in all of my appeals, I've never had to file a motion for stay. Not in any of them. And neither did I in my writ petitions. So I've seen other people do it though, and I've seen various, some people succeed, some people fail. The only other thing I want to mention is there is a fancy way. I'm going to use the word fancy here. You can get a stay using something called a supersedious bond. And I have a separate video on that, so I won't go into it in detail. But if you want to see how to get a stay by filing a supersedious bond, first off, you have to have a lot of money usually, because you're basically paying up front. So like say you lost your case and there's like a judgment of $3,000 against you. You're basically paying the $3,000 up front, but it's held on deposit by the court. It's a supersedious bond. And that I don't even think the judge can deny a stay. I think it just the fact that you file it instantly triggers the stay. It's a pretty cool mechanism for people who have the money lying around. Anyway, with that, I'm going to go ahead and end this video. If anyone has any questions on stays, or if anyone has any experience in the court system with getting stays, especially in the other various states, because they might be quite different from Nevada, feel free to post it in the comments below, and I'll see you guys next time.